All right, very good morning, San Mateo Dental Society. My name is Dr. Bardia Hariri from New York Life, and I'm specialized in asset protection, tax reduction, and overall financial planning for dental offices. This morning, I have the pleasure to introduce you to our estate planning attorney, Amir Atashi Rang, the principal and founder of the Atashi Rang Law Firm. Amir is certified specialist in estate planning, trust, and probate law, and works closely with medical and dental practitioners to create their custom designed estate plan and helps his clients with their estate and asset protection strategies. Over the years, Amir and I have been serving many mutual clients with their estate tax plan and probate protection strategies. Amir has a Master of Law in Taxation, and when he's not in his office, he enjoys traveling around with his dog, Blake, and he loves playing tennis and helping others. Ladies and gentlemen, I give you Amir Atashi Rang. Amir, please feel free to start. Also, please, if there are questions, ladies and gentlemen, you can leave it on the chat box, or we are going to have also a question and answer after the conversation that we will have. Amir, please.
Thank you so much, Badia. Thank you so much for the warm welcome, and a big thank you to Jim and also the Dental Society for giving me an opportunity to come and speak to everyone this morning. As Badia mentioned, we've worked hand in hand helping a lot of clients over the years, and these are mostly business owner clients that need estate planning for their personal assets, and then some planning for their businesses as well, business succession planning. That's what we're going to get into today. As Badia mentioned, we're going to basically get started with the introductions. As you can imagine, I used to do these seminars in person, so we used to have refreshments and brownies and cookies, and things are dramatically different these days, but I promise you'll still get the same experience out of this workshop. Keep in mind that detailed personal questions are always tough. Those are always tough to discuss in a group setting, so you may want to save those for a quick chat with me via email or separately when the workshop is done. What we're going to be covering today, and this is just sort of an overall agenda. We're going to talk about the basics for estate planning, the Achilles heel for estate planning, which is people often not connecting their assets to their trust. That's number two. It's missing the funding of the trust. I'll give you some pointers about those. We'll talk a little bit about asset protection, basically selecting the right entity for a business, and also business succession planning. These are tips for folks that either are solo practitioners or they have business partners, right? And they're contemplating how to do things better and more efficiently moving forward, and also maybe even creating exit strategies for what ifs, what happens in the horizon if one business partner gets incapacitated or something happens, they want to leave. We're also going to talk a little bit about taxes as well, estate taxes. Estate taxes is just another nice way of saying death taxes. I know it seems like it's a lot of stuff, but we're going to get through these sort of methodically together. Before we get going a little bit further, just a little bit more information about myself, y'all. I grew up in Palo Alto. I went to middle school and high school in Palo Alto, and went to undergrad at Santa Clara University, and then got my law school degree at UC Hastings in San Francisco. And as Badia mentioned, I am a tax practitioner as well. I have a master's of law in tax. And we've been blessed to help a lot of folks since 2005. That's when I started this practice many years ago. So even though I look really young, keep in mind that I've been around the block a couple of times. So with that said, let's get going here. There's basically 4 basic components to a good estate plan. You always want to make sure that you're keeping control of your stuff if you're unable to take care of it. It's logical. It's a no-brainer, right? And you want to have an effective plan that's going to transfer your stuff to your intended beneficiaries in the least complex way to avoid fees and administrative hassles. Of course, we always want to protect our assets. This could be from a car accident, or it could be from a claim at work, right? It could be a work-related claim. And also, we want to look into the horizon and protect our beneficiaries, sometimes from themselves, maybe because they're a little bit immature, and also from others, potentially from, let's say, an adult child getting into a dissolution proceeding, and then the inheritance that you're planning to leave for them, right, becomes jeopardized if that adult child gets separated or divorced. So these are the basic 4 things that we go through when we're talking to clients about estate planning. And I've structured these slides today as sort of mistakes to avoid, so that it's easy for you all to keep these in mind, these little tips, these little golden nuggets, as I like to call them. We're going to go through these first few slides pretty quickly because they're introductory. Okay, and if you have any questions, if I'm going too fast, please put your questions in the chat or the Q&A. So believe it or not, even among dentists and doctors, we're shocked to discover that most physicians and some dentists, I should say, they don't have their own advanced healthcare directive set up, right? And what are we talking about? This is basically if you are unable to make medical decisions for yourself, you always want to give that ability to decide on your behalf to another agent. That's done through an advanced healthcare directive in California. And durable just means that it lasts through your incapacity. And it's pretty simple. California has created a template. I'm sure you all have seen it before. When I went to go get my wisdom teeth pulled many years ago, I was shocked that the surgeon wanted me to fill out an advanced healthcare directive. I wanted to ask him, are you sure you're doing the right surgery? This is for my teeth, right? But in all seriousness, any surgery or any procedure you have had, you've probably run into this advanced healthcare directive. It talks about your end of life decisions, which unfortunately people reduce to pull the plug and don't pull the plug, right? It's that document, and also you naming your healthcare agents. So please don't forget about that piece. It's often overlooked in these instances, and it can get pretty customized as well. Some clients have specific wishes about their memorial, their services according to a particular faith, etc. All of those details are housed within the advanced healthcare directive. But on the healthcare side, it does not stop there, right? Oftentimes people fill out the canned advanced healthcare directive, let's say through Kaiser, and they stop right there. So golden nugget number 2 is don't stop right there, because for healthcare related information, you always need to cover the HIPAA base as well. And what is that? I mean, you all know HIPAA is the federal law that protects confidential medical information, and there's an equivalent in California. The abbreviation is CMIA. It's the state equivalent for protecting medical information. The point here is that you always want to make sure that in addition to the advanced healthcare directive, there is a separate rider or a separate document that is what's called a HIPAA release, a release for confidential medical information to your healthcare agents, right? Now, usually, you know, what hits the fan is when a physician or a hospital does something wrong, right? And then the loved ones want to find out what transpired, right? Somebody fell from a bed, right? An elderly person, something like that. And guess what? If there's an occurrence like that, most of the hospitals will say, we're sorry, this information is protected by HIPAA, right? The only way that the healthcare agent can unlock that information is with a separate HIPAA rider or a HIPAA release so that those agents can look after that person who is incapacitated, obviously, and may have fallen from a hospital bed, right? So please don't forget about the HIPAA release in addition to the Advanced Healthcare Directive as part of the healthcare documents. These are all incapacity documents, as you're sensing, and we're going to keep going with this theme of incapacity planning for now. Why? Because incapacity planning is the basic foundational block for any estate plan. You want to cover incapacity planning for healthcare and also incapacity planning for financial decisions. Again, any good estate plan needs to have as its foundation incapacity planning. Otherwise, it will fail. I know we all like to think that we're immortal and that incapacity will never catch up to us, right? We're going to keep running until the day that we're just out. But that's not the case. Most of us will suffer long periods of incapacity, mostly because of modern science these days, right? So what do we do with the finances? Well, let me tell you what happens if you don't do anything. Because as you can imagine, the state of California has already created all these rules for folks because most folks do not take the time to plan. And this is called a conservatorship. A conservatorship is probably the most humiliating thing any person can go through. It's where a court in the local county superior courthouse will strip somebody of all of their due process rights and say that you no longer have the right to make financial decisions for yourself or healthcare decisions for yourself. And that power is going to go to this other individual, right? That should be avoided at all costs for everyone. How do you avoid it? With basic estate planning. How do we avoid conservatorships? Same thing, power of attorney for finances and creating a revocable living trust. Here's a quick, simple way of remembering these things. These documents that you sign will enable a financial agent to step inside your shoes and do things on your behalf when you're unable to do it. That will avoid a conservatorship proceeding. And the same thing goes for the trust. As you're saying, we're using sort of a bucket example, like a chest or a holding tank example. The goal is for you to designate a trustee or a successor trustee to look after your finances if you're incapacitated. Now let's get a little bit more granular. Powers of attorney. Most of us know what these things are. And I just explained it in the simple terms. It's a document where you appoint somebody to act on your behalf on financial matters. There's 3 different types of approaches here. Most of you may have seen a statutory short form power of attorney. This is a power of attorney that, again, the state of California provides in a way for free. They want people to fill these out because the state of California doesn't want for people to go through a conservatorship proceeding and go through the courts because the courts are already busy enough, right? The statutory short form power of attorney is a 3-page document that if you were to Google, you would find a sample for it, probably from the state bar or some county law library. And again, you fill out your name, you fill out the agent that's going to step inside your shoes, you get it signed and notarized. That's one channel. The second channel is a more robust power of attorney that's customized. Barry has seen these before. These are sometimes 30 pages long. For business owners, they're for sure 30 pages long. And they get very granular as to what the agent can do, not just on the personal side, like pay for the mortgage, pay for property tax, et cetera, but also on the business side to deal with collections, right? If the business needs someone to look after it, to pay for payroll, et cetera, that comprehensive general durable power of attorney is more robust. The revocable living trust is also an incapacity planning document. again, think of the revocable trust as a holding tank that you create. You place your assets inside of it. And again, you designate a successor trustee to look after those assets within the holding tank if you're unable to do it. Oftentimes, in this state, most parents forget that these powers of attorney are also important for their kids. So I don't want to overlook that part, right? If you all have kids that are in high school that are right about to go through that lovely college application process, right? That's the right time to make sure that before those kids turn 18, before they go to college, because as adults, those kids need to have a financial power of attorney and also an advanced healthcare directive and HIPAA release naming their parents as agents. Guess why, right? I mean, you've seen all these stories. Kids go to their first party and they do certain things that they shouldn't have done, right? And then they end up in the pharmacy at the school and the parents are shocked and worried and want to get information and they're calling. And then guess what? If you don't have these documents for the kids, and this would be in every instance, the school says, oh, your child is an adult. We can't tell you what is happening with his physical care, right? This is not like when he was 9 years old anymore. So you need to have these incapacity documents for adult kids right when they're going to college. Otherwise, I've personally seen some pretty undesirable things for parents to deal with, like getting a conservatorship for an adult child. All right, y'all. If you aren't having fun now, so let's really roll up our sleeves and get into estate planning. Okay. So the good news is we've covered incapacity planning. We've talked about healthcare and we've talked about financial incapacity planning, right? And now we're segueing into creating a comprehensive plan for transfer of wealth. All right. So as Badia can tell you, every plan is slightly different. And I can't tell you how many times when we meet with folks, they start the line by saying, well, I have a very simple situation, right? I have this one house and I have this 1 or 2 kids and it's really a simple situation, right? And then you peel back the layers a little bit. Maybe they have a rental property that's co-owned with a family member that they're not on good terms with, or they've got other issues, like there's maybe a kid from a prior relationship, right? All these other things that may be going around in that estate plan that need to be, in all seriousness, need to be looked at carefully so that this individual does not get a cookie cutter plan pasted on top of them, right? The plan is made to fit them. So these estate plans are in effect comprised of revocable living trusts, right? Being used as a holding tank to avoid probate and to minimize taxes, to reduce family conflicts, and to protect beneficiaries. How does a living trust, how does a revocable trust do all those things? Well, by your active instructions within the document, right? You've got 3 kids and the oldest 2 are great kids, but they really shouldn't have anything to do with finances, right? The 3rd child, even though they may be the youngest and maybe they're only 27, is great with finances. Maybe that child should be listed as your successor trustee. Why? To reduce family conflicts, right? So those are the types of things that Barry and I often consult with clients when we're chatting with them, because clients have a tendency to say, well, I'm just going to list my oldest son as the successor trustee, right? Because it's a very natural reaction to say, I want to trust my oldest son to do these things on my behalf, even though maybe the oldest son has already had credit issues, is having difficulties paying his expenses, et cetera, the parent always wants to be forgiving. But in those instances, it's a horrible decision to name that son as the successor trustee to be the arbiter amongst his other two siblings, because they're going to get themselves into a whole lot of trouble as the person holding the bag, running that trust. It's these types of subjective counseling-based discussions that we have with clients to figure out how to do certain things, right? Sometimes it's not appropriate for one child to get all their inheritance. That's just the way it is. And it's not that that child is not loved. If anything, they're loved even more, right? Maybe that child is going through difficult circumstances. Maybe they have emotional issues. Maybe they have developmental issues. Maybe their inheritance needs to be kept in a trust so that another individual looks after it for them during their lifetime. Again, those are the sort of things that have to be discussed in these types of plans. And of course, you can't forget about who's going to get the house, right? So oftentimes, Barry and I deal with situations where there's one house and there's 2 kids or 3 kids, and they all want the house. Those things have to be, again, discussed and specifically included within the document to keep the peace among those 3 kids. Otherwise, they're going to take that generous blessing as an inheritance and basically ruin it. All right, so what's the result of a comprehensive estate plan? You're basically trying to centralize the management of assets by putting them in a holding tank and naming one person as its overseer, as its successor trustee. It eliminates probate court involvement, and I'm going to talk about that by fast forwarding just a little bit. What is probate court? Probate court is that administration that happens in each county superior court when people die. Probate court sneaks in, right? Jumps out from behind the bushes, literally. It's that boogeyman that everyone wants to avoid. Probate court in California has sort of the connotation like it's the plague, right? Nobody wants probate. Probate is bad. Why is probate bad? Cost, takes time, and it's a public proceeding. Here's what I describe as a probate hook. What is the hook that catches people to pull their estates into that court proceeding? Just for definitional things, decedent is not a desert, right? I want to make sure that we're on the same page here. Decedent means the person who has died, right? It's not decadent. Decedent, so the person who passed away had a will or no will, and in California had over 166K in their name as an individual, that estate goes through probate. Let me be more specific. You have one account with just one name on it. So I'm just going through the permutation of married folks here, right? Just one spouse's name or one partner's name on there. That account has over 166K in it. And that account does not have beneficiaries. In other words, you didn't listen to Bardia when he kept telling you, you need to designate beneficiaries. There's a very, very serious reason for that. Naming beneficiaries avoid probate, right? For that one account that doesn't have a beneficiary that goes over 166K, that will go through probate, and it will take a good 1.5 to 2 years for the court to say, here's the rightful recipient that should receive this asset. So going back to my prior slide, eliminating probate court involvement, that's of huge importance. Because if $1 million in California goes through probate, just a basic home here, right? That's going to take 1.5 years, and it's going to have at least $40,000 to $50,000 of costs and fees for the attorney, for the administrator, for the probate referee, for the filing fees, all of these little hands there that suck up that money. It's not even a tax. That's the administrative costs. So when I keep referring to my handy dandy prop here, my cup, and I say that the trust is like a holding tank, that it's really important to centralize the management of assets and link them with this trust so that they are not in your name as an individual anymore. Going back to my last example, the assets that are within the trust do not go through probate. I know it sounds like it's hocus pocus, and I'm just making this stuff up on a Saturday morning. I promise you it's not, right? It's overly simplified, of course. Assets that are placed inside the trust don't go through probate. So what does that mean? It means that the house needs to be titled in the name of the trust, or the bank account needs to have a beneficiary on it, and the beneficiary needs to be the trust, right? It's that sort of meticulous vigilance, I want to say, right? That awesome advisors like Bardio look after when they're helping their clients, is to make sure that anything that is new that's coming in is always connected to this instrument. Otherwise, it will go through probate, right? That's the biggest Achilles heel for living trusts. We already talked about handpicked trustees. Probably the biggest, besides forgetting to put the house in the trust, right? The second biggest mistake that we see is folks naming the wrong trustee. Like in my example, naming the oldest son just because he's the oldest. Trustees are not court supervised. A bad trustee can wreak havoc for years before they're forced by a court to give up the hot seat, right? So picking the successor trustee is of utmost importance. Sometimes clients even pick a bank to be the trustee. They don't want their 3 kids involved in that decision-making process. They're basically trying to spare their kids that agony of dividing who's going to get dad's credenza, right? Because I've seen literally 2 grown brothers fight over their father's credenza. And before that case, I didn't even know what a credenza was. A credenza apparently is a piece of furniture, right? That you can have next to your desk. But in all seriousness, you got to pick the trustees accordingly. Privacy. I already mentioned, if you go to court, probate court is public. When you do your business, your estate planning through a trust, that's a private document that is not overlooked by anybody. I want to talk about taxes in just a second. All right, asset protection. I think this is what most people want to hear about. So let's get into it. What are we talking about? So during life, one of the biggest things that we see that's overlooked is long-term care. In other words, people work, they accumulate, and then all of a sudden an unexpected thing happens and they need long-term care for many years, and that expense basically tanks their estate. Nothing goes to the kids or something like that, right? So please talk about that with Bardia. That is his domain. That's in his wheelhouse to help folks figure out how to plan for that occurrence, because otherwise you're not doing asset protection properly if you're not covering that initial base. All right. The other thing we want to talk about is asset protection after death, asset protection for kids, right? Maybe one daughter is involved with a significant other that you don't totally agree with, right? And their relationship is rocky. How do you protect that daughter's inheritance after your passing? So we're going to talk about that a little bit more. I don't want to hit too hard on long-term care. If you haven't read this book, The Conversation, it's a really great piece, eye-opener for long-term care planning. All right, let's talk about entity selection. So we're talking with licensed professionals here today. So oftentimes the question is, how do we better protect our personal estate if we're involved in these business activities? Right, you have your dental practice. Let's say you own your dental practice and let's say you own the land, you even own the building on the land for the dental practice, right? So now we're presenting a little bit of hypotheticals, and then we're going to look at our palette here for the different flavors of entities that may be of interest, that may be beneficial. So I'm sure you all have heard of corporations, LLCs, LLPs, LPs, and GPs. Let's go through them pretty quickly. So corporations oftentimes are broken down into an S corp, which is labeled as a small corporation. It's a pass-through entity. There's no corporate level tax, right? Think of the corporation as a sieve. It's looked through it. It's a conduit, and the income is attributed to the shareholders. With a C corp, that's not the case. There's two levels of tax. The corporation has a tax level, and then once it gives income to the shareholders or the owners, they also have another tax level. You're probably wondering, well, why would anybody want a C corp, right, if there's two levels of taxes? Great question. Actually, there's really great reasons for having a C corp, especially for income tax planning purposes. For certain business owners, that's something that you need to discuss with your CPA or accountant, especially given the last rounds of tax law changes that came about. You may have heard of professional corp, right? Sometimes I refer to my law firm as, oh, it's a professional corporation, meaning that my corporation is an S corp that has been registered with the State Bar of California as a professional legal corporation. Ditto for dentists, ditto for doctors. Once you create your entity, that has to be registered with the governing body, right? And of course, they make sure that the name is not confusing, that the owners are who they say they are, all of those things, what the ratio, the percentage of the owners are, et cetera. LLCs. LLCs would mostly be pertinent for folks that, in my example, that own the land and the building for their practice. The land and the building may go inside of a separate LLC, separate from the dental practice itself, which may be a professional corporation, or which may be an LLP, and I'll discuss that a little bit further. So that's a little bit about dividing up risks and a little bit about asset protection, is that if you do own the building and the land for your practice, and you already have a professional corporation, it's likely not a great idea to mix those two things together, is to create different shells for these different business activities and start getting in the frame of mind of succession planning for your business, not just estate planning for your personal home, for your retirement account, right? You want to start looking at this other activity needing its own succession planning, its own estate plan. Let's go through these different flavors a little bit more. LLP. LLPs are for licensed professionals, architects, attorneys, dentists, doctors. No other folks can create LLPs. So if you are in a business partnership or you're a dentist and you're considering forming a partnership, what are your options here based on these choices, right? If there's two of you, in other words, or three of you, you can have a professional corporation with multiple shareholders, or you can have an LLP. What's the difference? The limited liability partnership is basically designed by the state of California so that each partner's activities is firewalled from the other partner. That's the limited liability partnership. So for dentists and doctors that are in groups of 2 or 3, right? Your options are a professional corporation with multiple shareholders or an LLP. What's an LP? A limited partnership cannot be used to run your dental practice, right? A limited partnership is very similar to an LLC. I would compare it in its function and characteristics to an LLC. It would be designed to hold the investment property for your building, right? It would be designed to hold that land and the building. Could either go in an LLC or in an LP. What's the difference between an LLC and an LP? An LP requires two people, whereas an LLC, you can just create it by yourself. You can have a single person LLC holding the land and the building for your property. But if there's two of you and you both own the land and the building, then you can either do an LLC still, or you could also do a limited partnership. A limited partnership breaks down the ownership between a general partner who absorbs the liability and a passive partner, the limited partner, who is shielded from liability. If you have investors, if you have non-licensed business partners, oftentimes the limited partnership is a great strategy for the non-licensed professionals to be owners of the land or the building without incurring any liability, because you would remain as a general partner. I've listed GPs, but I'm going to go through it pretty fast. You rarely see a GP. A general partnership is basically if two people, if me and Barry say, we shake hands and we say, tomorrow, let's go open up a taco stand, right? Just by that mere act, if we start working together and doing business activities, California law says that's a default general partnership. Of course, it can work, but it's not recommended because there's no asset protection for a general partnership. The general partners are basically liable right from the start, whereas all the other entities that we just discussed, corporation, LLC, LP, LLP, all of those provide asset protection. And here's how. If your house is inside of your living trust, like we discussed, and your business is operated through a corporation or through a limited liability partnership, and something goes awry here, something blows up here, this is designed to keep that mess within this shell and not have it spill over to your personal home in your living trust, right? So that's the important, powerful nature of picking the right entity and sometimes needing multiple entities. Barry and I had a call recently with a client that had a chart that had multiple entities for various reasons, right? Multiple rental properties out of state, a holding company, given the nature of their business, et cetera, for asset protection and income tax planning. So these two things are often combined together when you're doing them in a thoughtful way. All right. Business succession planning. When I first started my practice back in 2005, I didn't have a business partner. The State Bar of California for lawyers automatically puts out a business succession plan. Why? Because they know that if something happens to that one attorney, all their clients are going to be, you know what, right? Left out in the cold. So the State Bar of California creates this sheet that says, Amir, make sure you name a practice administrator so that if I can't run the show, somebody else can step in legally who's a licensed attorney and deal with my client files and give notice to the clients. Same thing here. For my clients that are psychologists, doctors, dentists, any licensed professional, architects, and they're just doing it by themselves, right? Just roughing it out. Really important to do business estate planning for yourself. You have to have a mechanism where you discuss with a key employee or a great colleague that, hey, if I can't run my show, you're okay stepping in and doing this thing for me, right? Giving notices. And once they agree, you want to formalize that in a piece of paper so that that person can step inside your shoes, not for your healthcare decisions, not to pay for your property tax for your home, but actually to deal with your clients, right? All that hard work that you put in for years, you want to create a system for somebody to look after it if you cannot do it. Just to be clear, you cannot name your Uncle Joey to be that person, right? They need to be a licensed professional in order to deal with those files. All right, multiple owners. I can happily say that I have a business partner for many years now. Her name is Amanda, and she's worked with me for 10 years plus. And of course, we have exit strategies because that's the way life is. Stuff happens, right? One person wants to move away. One person gets ill, right? You don't want to be chasing your tail in that time of crisis. There's going to be a time where paths will separate, and you might as well have the mechanism set in place as to amicably part ways. Not, you didn't pay for this, so I'm not going to pay you back, basically, right? Which happens if you don't have a plan. What does it mean? It means having basic rights of first refusal, right? You probably have heard of those things. It gives one partner the ability to purchase the other partner's share, but do it according to a system, a way to appraise, value the business, and then a way for that person to buy out the departing partner's share. I always highly recommend putting ADR, alternate dispute resolution mechanisms, within these agreements as well. Because even if there is ruffled feathers, it forces the parties to go and mediate and get things done without actually going to court. So if you are in a partnership and you don't have a business succession plan, I would urge you to put that at the top of the list, in addition to your own personal estate planning as well. Sometimes just to reduce this to its common denominator again, incapacity planning. The bylaws of a corporation, the operating agreement of an LLC, need to somehow discuss an interim manager or an interim officer in case of incapacity, right? That's what we're talking about. Even if it's a 2-week car accident, payroll still needs to happen, right? Things need to function. All right, we've brushed upon this. Adult kids need protection too. They're going through divorce, or they've got credit issues, or let's say they're a contractor and they get sued quite often. How do you best provide for that child? It's by keeping it in trust for them. I used the same sort of example at the beginning of our chat when I said maybe a beneficiary is too immature or has certain difficulties with basically running their own life. Same thing. This could be for the adult child that is a contractor. And let's say she does great, she makes a lot of money, but it's an industry where you get sued, right? And the parents want to provide for her, but do it in a smart way. So they would keep her inheritance inside of a trust, so it never leaves the trust, right? Instead of the inheritance coming out of it and going into her individual personal bank account, that inheritance remains in the trust and takes advantage of the shield that mom and dad's trust has after they pass away, because that trust becomes irrevocable, and the daughters, the general contractor, the daughter's creditors cannot get at mom and dad's trust once it becomes irrevocable. They're not around. I can't say enough about this piece. The timing of inheritances is really, really important to think through and not botch, basically. We already talked about probate. We want to avoid it. Probate is that boogie monster that nobody wants to deal with, right? All right. Fabio's favorite part of the conversation. Estate taxes, death taxes, right? All right, y'all. So okay, so let me set up the progression really fast. When I graduated law school 22 years ago, there was an estate tax exemption. Think of it as a coupon that the federal government gives you as a US citizen or a green card holder. And the coupon says you can transfer wealth and not pay death tax, not pay estate tax. That coupon back 22 years ago was as little as 1 million. So if a married couple had over 2 million bucks 22 years ago, going over their coupons, right? They were a rich family and they had a taxable estate. Anything over the 2 million bucks would have been taxed 40%. Okay, I hope I got everybody's attention with that. Now, the exemptions are so huge, nobody talks about them. That same exemption that was only $1 million 22 years ago is now 12 million plus. So if you're married or you have a partner, you have 12 million and your significant other also has 12 million. So conceivably with $24 million of exemptions, you can transfer that wealth to your kids and loved ones with no death tax. You're probably thinking, wow, that's great. I don't have to worry about this for a long time. Well, not so fast, right? So please keep in mind that in the year 2025, these exemptions that are 12 million per person are set to go down to 5 million adjusted. So it'll be 6. So they're going to be half. They're going to go in half in a few years. So for folks that are listening that are still in their sort of the work mode, right? And they're accumulating, and you can look at your own life expectancy and look at the size of your estate and look at these numbers that I just mentioned. If you see your estate at some point going above 10 or 11 or 12 million, then you may want to do certain things before the year 2025, before those exemptions literally dissipate and disappear. You may want to actually start divesting and gifting while you still have those exemptions. It's something that Barry and I are talking quite often to clients these days, is the timing of that gifting. As you see here with the slide, it just depends. These things depend on who's running the government. Is it the Republicans or the Democrats? How much money the government is spending, and whether they need to collect, right? So the collection part comes in. I want to make a quick analogy here about the collection part. Most people didn't even flinch when several years ago, the rules for IRAs and retirement accounts were changed dramatically. Before these rules were changed, adult kids could keep deferring the income taxes on mom and dad's retirement accounts for years. And all of a sudden, with one little flick, that rule was turned upside down. Why? Because of collections, right? It's the IRS and the federal government wanting to collect from people's retirement accounts and saying, we're sorry, mom and dad. Once you're both deceased, the kids only have 10 years on those retirement accounts. After the 10 years, all of the income taxes that have not been paid have to be paid. That's what I'm talking about, collection. It's very similar to what's going to happen with the estate tax, is that the way the government is spending money, that they're going to need to collect by reducing those exemptions to collect more death tax. All right, y'all. So this is a quick summary of what we've gone through. The trust helps avoid probate in court. It helps those nasty fees from coming into the picture. You save time. It's a private process. There's no court involved. There's no probate referee trying to shake you down for some fees. The trust helps you do tax planning, control planning for sure. We talked about that a lot, where you keep control over your assets. and it can keep assets safe for beneficiaries if they're young, if they're under 18, or as we discussed, if they're adult beneficiaries that need that need help protecting their inheritance. All right, Jill. So this is a little bit of information about me. There's my email address right there. I want to again give a big thanks to Jim and to Bardia and to the society for having me over today to do a sort of this informal chat with you guys. And for anybody that wants to hear my voice some more and you haven't had enough of me for this 1 hour, in all seriousness, if you want to chat with us, what we discussed with my business partners, then we'll give folks a 10% discount off of our fees that just mention the Dental Society, and we'll do our best. Barry, I want to give you the mic, sir. Thank you again for giving me the opportunity to chat here today.
Wonderful. Thank you so much, Amir. Very educational. Ladies and gentlemen, please, if you have questions, you can drop your questions in the chat bar, or you can raise your hand. Amir is also going to send a follow-up email with his contact details. Please feel free to reach out to him. If there's anything we can help you, we are more than happy to be a resource for the Dental Society. We give maybe a few seconds, just if anybody has any question, please raise your hands. Any question is a good question.
Yeah, don't be bashful.
If not, Amir, if you want, we can wrap it up and then we can have more personalized questions or emails, or they can reach out to you.
Actually, somebody I think raised their hand, or maybe am I misreading this? Christine raised her hand.
Oh yeah.
Yes, I was wondering if defined benefit plans that are set up for retirement, do they need to be moved into a trust?
So as I'm going to finish eating my banana, I'm going to defer this to Bardia and then I'll chime in because it's kind of like pensions and retirement accounts.
Absolutely right. So obviously it really depends on the tax bracket of your beneficiaries. Remember, the defined benefit plans, they're all subject to income tax. The question is, who is the beneficiary? Should the trust be the beneficiary at the trust tax bracket, or kids at their tax bracket? If you think kids are at the lower tax bracket, you can just put kids as the beneficiary. The defined benefit plans will be rolled over into inherited IRA, and kids will address the required minimum distributions and pay the taxes at their tax bracket. But if you think if your estate is at the lower tax bracket, you can keep the trust as your beneficiary. Amir, if you want to add more.
That's perfect. That's perfect, Bardia. The only other suggestion I have is if the kids are still not mature and so under 18 or maybe even under 22, right? You may want to still use the trust mechanism. Basically name the trust as a beneficiary, because you never want to list underage kids as beneficiaries of a defined benefit plan.
Got it. Got it. Thank you.
You're welcome, Christine. Thanks for joining us today.
Thank you for the presentation. It's wonderful.
Oh, I'm glad you liked it. I tried to make it with some introductory materials and then also build in some more advanced stuff. So I'm glad you liked it.
Thank you. Any other questions?
Please feel free to email me afterwards as well. I'm happy to direct traffic and give you some feedback. As Bardia mentioned, we'll work with Jim to circulate our contact information so that you all have that. And again, thank you to Jim, Bardia, and to all of you for joining us today.
Thank you so much, Amir. We appreciate it. Thank you, Jim. Thank you so much. Dental Society. Please reach out anytime. We will be more than happy to be a resource for you. Thank you.